Good afternoon, everybody. You're all very welcome to the latest instalment of our afternoon CPD series. This afternoon we'll be talking about family law and insolvency, and we'll be in essence revisiting our CPD from last June on this topic. I'm not going to speak for very long. I'm simply just going to quickly run through the features of Zoom, which I'm sure you're all very well accustomed to at this stage. And I know some questions have come in already in advance, but if anyone has any questions over the course of this evening, you can use the question and answer feature on the bottom of your screen, just along the bottom in the middle, or indeed you can use the chat function. Without further ado, I will hand over to Her Honour Judge O'Malley Costello, who has very kindly agreed to chair this afternoon seminar. And we have a number of fantastic speakers lined up, and Judge O'Malley Costello will introduce those in turn. Thank you, Judge.
So good evening, everybody. Certainly, I think there's been a huge interest in this seminar. I think we're told there's about 170 people who have indicated their wish to attend. And I think that, if you like, speaks to the great need for us to understand how family law and insolvency / bankruptcy link in together, because certainly when I was a family law practitioner, we had a great deal of concern about how we might link, if you like, the issues regarding the large asset cases with a knowledge of commercial law. And unfortunately, due to the downturn and due to the very grave difficulties affecting persons in society, the question very often now is not how are we going to manage the assets, but how are we going to manage the debt. And in that regard, I know that both judges and practitioners are very anxious then to hear the input which we will get today from the various speakers. This is part two. My colleague Judge Ryan, who has since retired, I think chaired the last seminar. And all of you will have the basics, if you like, from that seminar. And if you don't, I think certainly the Family Lawyers Association would make sure that you have any basic information which you might require in that regard. So as I said, this afternoon, we're going to move on to have a talk from, I suppose you know who the participants are, but just to mention, we have Mr. Morgan Shelley, who's going to speak about BL, who's going to speak about family law, the family home and bankruptcy, which is of great interest, of course. That will be followed at 5 o'clock by your colleague, Graham Hanlon, who's going to speak about insolvency litigation and the role of the solicitor. Then by Mr. Eugene McDarby, a personal insolvency practitioner, I think known to you from the last seminar, on where we are now with personal insolvency. And then we will finish with Keith Farry, who's going to, again, very well known to you all, who's going to give an insolvency update in terms of the case law. And my assistant then, Owen Fagan, is going to give you some of the, just explain to you on a booklet that's been put together regarding the existing case law to date. So without further ado, then I'll hand over to Mr. Shelley, who's going to speak to us about the family home and bankruptcy. All right, Morgan, thank you.
Good afternoon. Thank you very much, Judge. So I'm very grateful to the invitation to speak with you today. I've spoken to the chair of the Family Lawyers, Nuala, who's suggested that I cover two broad issues in terms of today's talk. The first is just an overview of what bankruptcy is at a high level, and then specifically issues around the family homes in bankruptcy. In terms of the context and why we need to speak about issues around the family home, there's quite a large number of principal residential mortgage accounts which are in arrears, around 5.5%. At the moment. So there's around 40,000 homes in that position, and that's the equivalent of around 7.5 billion euros worth of outstanding mortgage accounts. So if you're dealing with any particular client who comes through your door, there's a high chance that they may be one of those people. What's unusual about the Irish context is that a huge number of those cases are in arrears of over 2 years. So we have around 3.5 of those 5.5% of cases are in arrears over 2 years, and around 8,000 of which are in a legal process around 2,300 of which have been in the court system for over 5 years. So just in terms of what bankruptcy is, the best way of describing it is it's liquidation for people. If you think about company law, we have examinership, which is the equivalent of personal insolvency that some of the other speakers will be talking about today, whereas bankruptcy is liquidation. The person's assets are pooled, they're sold by the official assignee, and the assets, the value of the assets is then distributed amongst the creditors of the bankrupt person. And after the end of the process, the person's debts are written off. So the numbers are actually quite small. There was an initial rush after the legislation changed earlier in the last decade. Last year, there were 263 people adjudicated bankrupt, and only 13% of those were from creditor petitions. So there's two ways you can end up in bankruptcy. One is a debtor's petition, which is where the insolvent person themselves asks the court to make them bankrupt. And the other type is where creditors ask for the person's affairs to be wound up by the official assignee. It would have been in the past, bankruptcy was extremely onerous. You could be in bankruptcy for 12 years. Indeed, you could be in bankruptcy for longer than 12 years, even in a relatively straightforward case. That obviously changed. The periods have been reduced over time, and now bankruptcy only lasts for 1 year. So bankruptcy has gone from being something that creditors could terrify a debtor with to something that debtors can not terrify, but can threaten at least to their creditors. So last year, there were more people exiting bankruptcy than went into it, and 108 homes revested through a new provision that I'm going to discuss later. So to put that in context, the number of 263 bankruptcies is much smaller than the almost 2,000 people who got protective certificates for personal insolvencies, or the 1,700 arrangements that there were from personal insolvencies. So bankruptcy only applies in cases where the person's debts are in excess of 20,000 euro. So the limit on that is strict, and you can't go into bankruptcy unless your debts are at that level. It's best described as being a last resort after personal insolvency. I think there's a preference amongst all the professionals, and the system is designed so that if possible, someone can first of all resolve their debts in an informal way with their creditors. If they can't do that, that they can go through a personal insolvency, such as a personal insolvency arrangement or a debt settlement arrangement. And only if that fails will the person be eligible for bankruptcy. And it's actually one of the proofs in a bankruptcy that if you are a debtor who wants to bankrupt themselves, you have to demonstrate that you've made reasonable efforts to go through a personal insolvency. Or if you're a creditor, the judge still has to consider whether a personal insolvency would be more appropriate. It's a highly technical area, in particular for creditors' petitions. So if you're trying to bankrupt someone who does not want to be bankrupt, it becomes very technical. That's because the case law suggests that because the effects of bankruptcy are in effect penal, it's almost treated like a criminal statute. So there has to be absolute strict compliance with the bankruptcy code and the bankruptcy legislation. So for instance, if you make a statutory demand of the Bankruptcy Act and you miscalculate the interest and you seek €2 or €3 more than you should have sought, that will lead the entire process that follows it to be eligible to be set aside, be vulnerable to be set aside. The petition requires an act of bankruptcy. With the debtor, that's straightforward. The person can effectively make a declaration of insolvency. For a creditor trying to bankrupt someone, they need to have an act of bankruptcy, which is usually either a nulla bona on a judgment or alternatively a bankruptcy summons. And a bankruptcy summons is a bit like a winding up notice. It's a formal notice issued by the High Court to someone that if they don't bring their debts to that creditor below 20,000 euro, they will be eligible for bankruptcy. Now, the effects of bankruptcy are relatively straightforward. They really come down to three things. The first is that all of the person's property vests in the official assignee. The official assignee is like a liquidator, and they take on ownership of all of the assets of the bankrupt person. But they can disclaim any property, including property which is unsaleable due to a mortgage. In terms of the ongoing payments, although bankruptcy only lasts now for a year in the vast majority of cases, you can be required to make a bankruptcy payments order, which is basically a monthly payment every month for a period of 3 years. But in setting the level of the bankruptcy payments order, generally, which is done by agreement, but if necessary, the court can fix the level of it. The court will have regard to your reasonable living expenses. In the context of the family home, obviously the family home would have to be borne in mind in that regard. And that can be varied over time if there's a change in material circumstances. Now, I know one of the questions that's going to come up later is in terms of the interaction between family law proceedings and dealing with marital breakdown and bankruptcy. One of the important provisions of the Bankruptcy Act is that any transfers or settlements or conveyances of property in the 3 years before bankruptcy are void as against the official assignee. And they're void against the official assignee if the bankruptcy happens within 5 years and the person effectively wasn't able to pay their debts at the time. And that does not apply to a purchaser in good faith for valuable consideration. The usual rule applies there. But also, that doesn't apply where there's been a settlement of property before and in consideration of marriage and civil partnership. And the before obviously is central because in most cases you'll be dealing with a transfer that's happened in the context either of a marriage or a civil partnership or the aftermath of marriage or a civil partnership. So a bankruptcy ends, it now, rather than the 12 years that it once was, it's now down to 1 year, subject to the provisions in relation to the family home that I'll come on to shortly. Any unrealized property remains vested in the official assignee. So the official assignee has time to deal with any property or assets that he's been dealing with even though the bankruptcy has come to an end, but the person is released from the provisions of the bankruptcy. That's subject obviously to two things. The first is bankruptcy payments orders continue for 3 years, but also the court can extend for 8 to 15 years the bankruptcy period if there's been a failure to cooperate, and in particular if assets have been hidden or concealed. But the main effect of a discharge from bankruptcy is the person's debts are entirely discharged. Now, bankruptcy gets rid of debts, but it doesn't get rid of security. So the secured creditor retains their security, notwithstanding the fact that the debt is in effect gone. So with those secured assets, the bankrupt's interest, subject to the security, obviously, vests in the official assignee. And in effect, any joint tenancy in the family home is severed and becomes a tenancy in common. And with any secured asset, the official assignee can sell or surrender it to the mortgagee if it's not a family home. And in practice, in things like buy-to-let properties or commercial properties, inevitably the secured creditor will appoint a receiver to non-private residences. So what happens when there's a couple where only one person goes into the bankruptcy and the other doesn't? Well, the secured creditor cannot go after the bankrupt person for any shortfall of the debt that's left after the security. But if there's a co-borrower, such as a spouse, the debt remains owing by the co-borrower in full. So you could be left in a situation where there are two spouses, one of whom is in bankruptcy. Their debt on the family home is written off, but the remaining spouse still remains liable for the full value of the outstanding mortgage. Secured creditors can, in theory, abandon their security and just go into the bankruptcy as an unsecured creditor. I don't think I've ever seen that happen. It would be very rare for a secured creditor to give up their security because then they'd just be an unsecured creditor like everyone else, and all the other creditors would share in the value of their security. They do have the option of valuing their security and becoming an unsecured creditor for the balance, but in most cases, secured creditors would simply just rely on their security and stay completely outside the bankruptcy. Now, there's this distinction in bankruptcy law dealing between the family home on the one hand and principal private residence on the other. A family home it has the same definition as the Family Home Protection Act or the 2010 Act, but there's additional protections for the principal private residence, and it's a relatively recent development. Is that after 3 years, any unrealized interest in the home, so be it a family home, a shared home under the 2010 Act, or a principal private residence, revests in the bankrupt, unless there's been agreement with the bankrupt otherwise, or unless the court otherwise orders. What that means in effect is that in practical effect, the official assignee will look towards the end of the 3 years, generally 6 months before the 3-year period ends. And the official assignee will assess, is there equity in the home? And if there is equity, or material equity, the official assignee will see it as their obligation to release that equity for the benefit of the creditors. But if there's no equity there, the likely outcome is that the official assignee will simply do nothing. And at the end of the 3 years, the bankrupt's interest, the equity of redemption that they had, will revert to them. Now, in relation to the family homes, this doesn't cover all principal private residences, but only family homes of a bankrupt or their spouse, as defined in the Family Home Protection Act 1976, or a shared home of a bankrupt or a civil partner under the 2010 Act. For that to be disposed, or the official assignee to deal in that equity, they require an order from the High Court. If the court decides to order the disposal of the property, and that's rare, the court can postpone that. Now, to put that in context, the reality is the official assignee, as a matter of policy, will inevitably seek to dispose of the bankrupt's interest in the family home to their spouse or their civil partner, or indeed a cohabitee. It's only if that person is not in a position to agree a value of the equity and to pay that amount that there will be any question of the property being sold on the open market. And the procedure that's followed is straightforward. The official assignee gets a valuation. The bankrupt or their spouse or the civil partner or the cohabitee can get an alternative valuation, and generally there's a negotiation, and the value of the equity is worked out. Now, if there is equity in the property, generally the official assignee will assert that they have a 50% interest. They've stepped into the shoes of the bankrupt. But that can lead to complications where someone who has been in serious financial issues for a number of years may not have been contributing to their mortgage, but their spouse may have. They may not have been in a position to pay the local property tax, house insurance, life insurance. So in those circumstances, you may have an argument, if you're acting for a spouse dealing with the official assignee, to say, well, actually, we've contributed a great amount of equity. Although if you have to go back through the entire history of the property, it may be that the bankrupt contributed more to a deposit, for instance, which can even that up. If there's no equity, that doesn't apply. In reality, either the spouse who's remaining in the home will purchase the equity of redemption, if they choose to, from the official assignee, or they'll just benefit from the 3-year rule kicking in. It's helpful, I suppose, to consider, if you're acting for the spouse of a bankrupt or a spouse of someone who's facing the potential of bankruptcy, to consider whether the property is likely to accumulate value in the coming years. If it's likely that in the 2.5 years before the official assignee seeks a valuation, that the property will increase in value. If, for instance, it's just about a negative equity now, but you feel as though it may gain value in the coming 2.5 years, it would be better to buy the equity of redemption for the official assignee straight away, or to value the equity as early as possible. To put this in context, and just to show the bona fides of the official assignee, this only happened 19 times last year in all of the bankruptcies that were there. So less than 1/5 of the number of cases where the property just vested straight back into the bankrupt at the end of 3 years. There's only 19 of these applications, and 16 of those led to settlements with the former bankrupt or their spouse, and there were no forced sales. In the entirety of last year, there was no forced sales under that provision, in comparison to the 108 that vested back. So if you're acting for a spouse, if there's any chance that they can purchase the equity in the home back from the official assignee, that will be facilitated. Now, one of the issues that crops up from time to time is how to protect a family home from creditors in general, and specifically how to protect the family home if you're acting for a spouse where you consider that the other spouse in the relationship is endangering the property and may, for instance, be the subject of a bankruptcy adjudication in the coming years. Obviously, you don't have to wait for a bankruptcy to come along. You can act earlier, for instance, to bring an application under Section 5 of the Family Home Protection Act, which allows the court to intervene to protect a property for the benefit of a spouse or dependent children. That can cover, for instance, deliberate inactivity. So I know one of the questions we'll be dealing with later involves how to deal with a situation where one spouse just completely disengages and leaves another spouse in the home. One of the ways to deal with that is to bring an application under the Family Home Protection Act, and that can be brought in the context of or separate from judicial separation or divorce. So generally, the advice would always be that if there's a danger of bankruptcy, albeit that the transaction may be void against the official assignee down the line, it's better to resolve the ownership. And it's especially an issue if you have the bank on side. If you're acting for one spouse who's been responsible and doing their best to pay a mortgage, and another spouse who's just completely disengaged, if the bank is on side and is agreeable to the first spouse taking on the full ownership of the property, that can be facilitated either through judicial separation or divorce, or through the Family Home Protection Act. And it's generally better to resolve that before the person has ended up in the bankruptcy process. In terms of protecting creditors, you may well be acting for a creditor in the context where bankruptcy might be relevant. Obviously, if some other creditor is petitioning to bankrupt a debtor, you want to look at the potential of getting a judgment mortgage, and it's important that you get your judgment mortgage 3 months at least before the person goes into bankruptcy. So if you have someone who has equity in a property, it's better to get your judgment mortgage in and preserve your position rather than have the person turn around and go through the bankruptcy process, in which case you'll lose any priority. That doesn't seem to apply if the creditor is a solicitor who's acting under Section 3 of the Legal Practitioners Ireland Act. It'll be often the case, particularly in family law proceedings, and I know from a few cases I've dealt with where the solicitor has and counsel have done a large amount of work on the assumption of recovering or preserving property for a client. And if you go down that route, you have the option of getting a declaration which entitles you to a charge over the property you've recovered and preserved. That doesn't seem to be affected by the 3-month requirement. So again, it's generally better to have your charge in place for the property you've recovered if there's equity in it, lest someone ends up in bankruptcy. That applies if you have an order that you're enforcing against another party in matrimonial proceedings. You'll want to get a judgment mortgage for any outstanding costs rather than waiting for the person to go into bankruptcy if that's considered risk. So I think I'm just shy of the 25 minutes there. I think we're going to take all of the questions together at the end, so I won't take any questions there, but as always, I'll circulate the slides afterwards, and if anyone has any direct questions, obviously I'd be happy for them to drop me an email if there's anything that they don't get a chance to raise at the end. Thanks very much.
All right, thank you. Thank you very much. Thank you very much, Morgan. And I think I failed to do a proper introduction of you. I handed over to you rather quickly, but of course, I think probably those looking in will know that you are a junior counsel and that you specialise in this whole area of commercial law, not to mention judicial review and other matters, and that you have indeed written extensively on insolvency as well. And certainly the input that you've given, which gives us some clarity. I think sometimes what happens in the bankruptcy court can be a little bit of a mystery to others who don't appear there regularly. So certainly that has been a really, really helpful expose of what might happen in certain circumstances. And I know that there probably will be many, many questions for you at the end. So thank you very much. Thank you. So I think we can go next now to Graham Hanlon. And I think that, again, he needs no introduction. Certainly appears regularly in the family court and indeed in the insolvency court. He is going to speak to you about insolvency litigation and the role of the solicitor. And as you know, as a practitioner, he specialises both in the area of family law and in insolvency work. So certainly that crossover is something from his experience in terms of the crossover of those two areas of law will be of great assistance to us this afternoon. So I'll hand over to you now, Graham. Thank you.
Thank you, Judge. I hope everyone can hear me. I'm not getting any indication that I can't be heard, which is great. So yes, we can hear you, I think. Wonderful. I can hear you anyway. Thank you. Thank you. So yes, and for the introduction, and I suppose it's because of the crossover that we have here in the office between the two areas. is one of the reasons why I've been anxious that family law practitioners in particular should become more aware of the whole area of insolvency, and indeed how it may well already be impacting on their own practice in family law and the relevance to it. There are huge similarities, and of course, like all areas of law, there are huge differences. And I suppose just to deal with the role of the solicitor first, in an insolvency situation, any insolvency application is first and foremost commences by way of the protective certificate which the personal insolvency practitioner would have applied for. He then puts together the arrangement and calls a creditors meeting. And the date of the creditors meeting is the first most important date for the solicitor, who then pretty much will become involved if the proposal is voted down. Once a proposal that a personal insolvency practitioner has put to the creditors of a debtor or debtors, as many cases have joint debtors, husband and wife or partners, if it's voted down, their option, of course, is to appeal to the circuit court or to the High Court, depending on the level of the secured debt. And it's that, I suppose, is the first major difference in the area of insolvency. There's a very tight window to actually issue and serve the application to the court or the appeal. It's grounded on a notice of motion and an affidavit of the personal insolvency practitioner, but it's only 14 days, and that's for issue and service. And that of itself is the fundamental difference, I suppose, as family law practitioners, where we very often work in an area where there's very little statute of limitations creep into our area of work. Cohabitation, of course, is the obvious one, but for family law proceedings in general, a statute as such is not something that we're overly conscious of. But in insolvency, it's the complete opposite. We have a very, very short window. And those 14 days, in fact, include the day of the creditors' meeting, which in reality is one day gone before you get the instructions. So now we're down to 13, and every other day of the week, including weekends, bank holidays. So we work closely with Eugene, who'll be speaking to you later, and we would always be encouraging, and thankfully he never has done it. He's never called a creditors meeting, for example, on the 18th of December, which this year fell on a Friday, which would mean that we would have to issue and serve an application if it had to be appealed by the 1st of January. And that's a fairly tight time frame. The papers then that have to be filed are, of course, a notice of motion and an affidavit. And you might wonder there's no other grounding kind of civil bill. There's already a record number generated by the personal insolvency practitioner for a protective certificate. So if you like, the debtor is already in the system, so to speak. And it's that number then, that record number, that is used to issue the motion and the affidavit. As I say, 14 days from the creditors' meeting, issued and served. And curiously, it also has to be served on the debtor. And this leads me to my next point in acting in insolvency cases. Strictly speaking, our client is the personal insolvency practitioner, but there are a suite of documents we have to file with the application, and one of them is the letter of instruction from the debtor. So we need a letter of instruction from the personal insolvency practitioner. He's instructing the solicitor to apply and make an appeal on behalf of himself and the debtor in relation to the arrangement that was voted down at the creditors' meeting. But the minute we get this letter, of course, from the instructing letter from the debtor to the solicitor, we're now in a position, I suppose, from a personal indemnity point of view, professional indemnity point of view rather, where technically we could be on the hook to both debtor and PIP if we are negligent in the handling of the file. Now, thankfully, it's never happened in all the years we've been doing this, but nonetheless, it is something that one has to take on board. There are a suite, as I say, of documents, 8 in total, that have to be filed with the application. So already you can see there's quite a degree of work. There's the notice of motion, of course. There's the affidavit, which is a grounding affidavit of the professional personal insolvency practitioner. a copy of the arrangement that was voted down, a certificate from the personal insolvency practitioner as to how the creditors voted in relation to the secured and the unsecured debt, and that's very important. And then the letter of instructions from the debtor in relation to appointing the PIP and instructing the solicitor. And all those documents have to go in, as I say, within the 14 days and be served. Curiously then, they actually have to also be served on the debtor. So the debtor is also served, which is kind of odd, I suppose, in many ways, if you think about if the debtor is kind of almost in that sphere of you're looking after their interests, not quite the client, because we see the PIP as the client, but nonetheless, we would see that we have the duty of care to them. We serve them the papers. A return date is then given with the notice of motion as an all notice of motion. And before the return date, we generally then will receive within 14 days the objection from the objecting creditor. Not all the creditors at a creditors meeting that the personal insolvency practitioner has called will have voted against an arrangement, and in most cases many of them vote in favour. But obviously if there's an objecting creditor and they have the vote to undermine the proposal, then the appeal goes in if they're the instructions. And that objecting creditor is the one then that puts in their objection. And on the first return date, of course, we're before the courts, and that date is effectively a date where directions are given. And those directions would be, of course, for a replying affidavit in detail to come in from the objecting creditor. And then time given for that, generally 4 weeks, and then another 4 weeks generally for a reply to go in from the debtor stroke PIP. And affidavits do go in from both. Now, I can imagine, I cannot see Judge O'Malley Costello, but I imagine she's smiling wryly, because I don't think those dates are ever, or those timelines are ever really met, 4 weeks and 4 weeks. Very often, very, very often, there is extensions of time to that. People need more time, particularly now anyway with COVID as well, but even before COVID, in fairness, those timelines were expanded out. And it's at that stage when we get the affidavit from the objecting creditor that we then need to drill into the life and the reasons why a debtor is where they are in life. And in many ways, this is where there is a huge similarity between what we do in a family law case and what we would do in a insolvency application before a personal insolvency application before the courts, because we do need to drill down in both areas of practice into why and how people are where they are, the finances of the debtor, the finances of an applicant in a family law case, how they got into debt, when they first got into debt, when they first fell into arrears with the family home, in particular the mortgage. And that, in most cases, is what people, as you can well imagine, are very anxious to ensure and try and secure through an arrangement that they can remain in their family home, or they remain in their principal private residence through an arrangement approved by the courts, if it's approved, that will actually get them back on their feet. And if we think about it, that was the purpose of the legislation. It is very much driven by a social policy dimension of government to get those people in society. And Morgan gave you startling figures, which we would be familiar with frequently, because we would get these updates through people like Eugene and so forth, of the amount of home loans that are in arrears. The whole purpose of the legislation was to get people back on their feet so they would play, or be able to play, an active part back into society again. So we're asking them much the same questions that we would be asking them in a family law case, going through that history as to how the matters were financed, as to contributions and so forth, and as to how then they got into debt. Their whole income, of course, is very, very important. Their income can change during an insolvency application, and the court needs to be appraised of that as it happens on affidavit. So in that sense, what we do in one aspect of the building here in relation to the insolvency end of it and what we would be doing in the family law end of it have a huge commonality. Our applying affidavit then goes in, and the objecting creditor has an opportunity to put in a further affidavit, and we would work closely with Keith in settling of those affidavits. The courts have clearly stated that they most certainly want the detail, so there's an awful lot of work. The courts do not like to see a kind of a general broad brush description of people's lives, because they have to analyze whether a proposal that is being put forward by a personal insolvency practitioner is worthy of approval. So the detail is very, very important. This eventually then, when the matter comes on for hearing before court, before someone like Judge O'Malley Costello, then the matter is heard on affidavit, and there's obviously the objecting creditor's legal representation there, as well as ourselves and the Insolvency Service of Ireland, who are also there on all occasions in an observatory capacity. They're also served with the papers from the outset. So there is a lot of work involved. There's a lot of paper generated, and just by way of example, that would be kind of typical, and that would be very typical of just one file of one debtor, and it can be more. So that would be the kind of volume of paperwork that's generated. Affidavits can run to 70 averments or more, and of course there are a lot of exhibits. So from that point of view, it is intensive. From a solicitor's point of view, it's stressful at the beginning to get it out and to get your application in within the 14 days. But once we've reached that threshold, then there is the degree of detail that's required from the debtor. And when we're preparing the affidavits, the replying affidavit on behalf of the debtor, that does require, of course, engagement with the debtor and attendance at the office. We would have a huge amount of cases which are husband and wife, or two partners, or what we would call a joint case. Those cases would have a huge commonality in relation to perhaps the secured debt, because they might both be on the mortgage, but their unsecured debt might be quite different. So somebody might have a credit card debt whilst the other person doesn't, but they might have a credit union debt. So again, they are individual cases that are prepared. In the main, there might be some degree of commonality, but there's a second set of papers for that spouse if they are also an applicant in relation to seeking a personal insolvency arrangement to be approved by the courts. From that point of view, when it comes then to the family law end of things, it always occurred to me as a family law practitioner that in examining, as we do, the person's financial circumstances that you're acting for, and in examining the person's financial circumstances who you're not acting for, when you see their affidavit means, whilst you don't have a duty of care to them, most certainly we're on notice, and we cannot be blind to the fact that when you're preparing an affidavit of means, it could be apparent from that document that there's a potential insolvency case that needs to be addressed, or that should be addressed. And in that sense, whilst the affidavit of means might not be as involved as a prescribed financial statement that is prepared by a personal insolvency practitioner for an insolvency proposal, nonetheless, we are every day looking at people's income and expenditure. Nonetheless, we are every day asking people, when we're settling affidavits, in reality, how can you afford this? We know as family law practitioners, we're all the time probing our clients to ensure that they're including all their expenses in their affidavits. And very often, and I'm sure this is something that we've all seen, whether it's by design or whether there's an element of fiction in it, but I don't believe it to be the case. Affidavits of means disclose that somebody clearly can't afford to meet their ends out of the income they're getting. So the question then for us as family law practitioners becomes a live one. Is the person sitting in front of you potentially somebody who could seek the benefit of the insolvency legislation and perhaps be in a better position as a result of being referred to a personal insolvency practitioner? And that's something that I really do wish to throw out to my colleagues in family law, because I suppose there is a flip side to that, which is always the nasty flip side. If you're advising someone in completing their affidavit of means and they're clearly insolvent on the paper, on the affidavit that you've prepared, that you're filing in court, then surely there is an onus on you to advise them of the availability of the insolvency regime. And if you don't, then are you exposing yourself to some degree of being told you were negligent in not alerting someone that you're preparing an affidavit for, that they should consider speaking to a personal insolvency practitioner? And all you have to do, in my opinion, should it arise in preparing your affidavit of means that someone's insolvent, is simply in the next letter to them, advise them that they need to talk to a personal insolvency practitioner, or you're advising them that they should, and supply a name or a number of names to them. If they don't take your advice, they don't take your advice. But you have at least ticked that box. And we are looking at people long before insolvency legislation came into being, who we've often thought ourselves, clearly these people cannot afford the lifestyle they have, or clearly these people are insolvent. So that is something that I think that we need to be more alerted to. When it comes then to and I know some people might have a reluctance to go down that road because of a concern, well, how on earth am I going to get paid? We all look forward to trying to get paid out of the liquidation of an asset. If that asset is the family home and it's now going to be subject to an insolvency arrangement, will that preclude me from ultimately getting my fees discharged? That's a matter you have to address, in my opinion. I mean, the recovery of fees is a matter we all need to address on a regular basis, and perhaps we shouldn't be waiting for the liquidation of assets for our fees to be paid. Very few professions do wait for some event to happen into the future. But nonetheless, I believe it's something that needs to be addressed. From an insolvency point of view, we are guaranteed our fees. Our fees are paid from the Legal Aid Board. Now, that said, it's a state scheme. We are possibly the poorest relation in the legal aid scheme when it comes to what we get. And people might find that hard to believe, but that level of pleadings, the total fee that we get from the Legal Aid Board per case is about €2,000. If it's a joint case where there's a husband and wife involved, it's 2001 and half that again for the other. But the same volume of paper is produced for each and every case. And indeed, we used to have a situation where there was no question of having being able to engage counsel. We now have to apply in each and every case and justify the need to have counsel. So Keith isn't automatically going to be included and we're not automatically guaranteed having representation in each case. Because that's the approach the Legal Aid Board has now taken, because they think that, well, perhaps a objecting creditor may withdraw their objection, and therefore why on earth did you need counsel? I personally, speaking from a social policy point of view, find it absolutely appalling that a piece of legislation that's designed to make sure people who have fallen into debt, most of them through no fault of their own, most of them anxious to continue on and make a constructive contribution to society, most of them struggling, most of them stressed. are not necessarily guaranteed, if they avail of the scheme, counsel to advocate for them. And yet other people in society who wouldn't be making such a contribution have counsel at a drop of a hat, and the cost of that service is extraordinary. That's my rant in relation to the legal aid scheme. I think it's unfortunate that the fees that are allocated in relation to this area of legal aid have been under attack, and consistently under attack, considering what the legislation was designed to do. That perhaps would put an awful lot of colleagues off from getting into the whole area. It does require a dedicated team here in my office to work with this. Aidan Dempsey is the principal solicitor that runs the department, along with other support staff, and they do nothing else but these cases, preparing them, making sure we reach the timelines, making sure affidavits are filed and delivered and served, and briefing counsel and applying for legal aid certs and so forth. So it does consume a degree of resources. That said, the crossover between personal insolvency and family law is not just in the fact that we're looking at people's prescribed financial statements and affidavits and so forth, but as you can imagine, the crossover is real. We have 180 personal insolvency applications between those that have been done and approved and those that are currently in the system. And we have done an analysis of it, and we're satisfied up to 30% of those people have a family law dimension to their lives. It should come as no surprise. If you think about it, very often the cause of breakdown can be financial. So if someone is in this particular situation, it's of no surprise perhaps that this is playing a huge part in their lives to such an extent that it's causing stress and has led to the breakdown of a marriage. So there is huge potential in the crossover in that the area would have led other business into the office, as well as just the insolvency aspect of it. As you can imagine, people who are insolvent, very often the marriage is under strain, and it has come to result in the necessity for the solicitors to get involved in relation to looking after that aspect of their lives. So I'm looking at the time, I've got 2 minutes left, and I think I will leave it there. Our role as a solicitor in an insolvency matter is very much to get to the heart of where people's problems are at and how they got there, so we can craft the affidavit that's settled then, so that it gets the application over the line. That's a very similar role really to a family law solicitor. So the crossover is huge, and I would strongly encourage my family law colleagues to look at this area more closely, not only with a view to perhaps looking at whether they wish to get involved in practicing in the area, but importantly to look at people's position and to consider your own professional obligation to perhaps sit down and consider whether your client should be advised that really the next consultation they need to have perhaps mightn't be with the solicitor, but should be with a personal insolvency practitioner. Thank you, Judge.
Okay, thank you very much, Graham. That was certainly very helpful. And just picking up from what you've said, in dealing with family law matters, I can often see how people come in to have their cases heard at the final hearing. And at that stage, one party or the other is coming in and saying, look, if we could have a bit of time, we might be able to come up with a situation whereby we could go down the insolvency route. And I certainly agree with you that it is so important that you do that at an early stage, and that since parties or since solicitors are aware as a result of seminars like this of how the insolvency regime can help their clients, that will lead to earlier intervention, which can only help find solutions. So we'll pass on now to Mr. Eugene McDarby, a personal insolvency practitioner, who is going to guide us a little bit through, I suppose, test cases or types of cases which he might have dealt with. And he needs no introduction to you as well, because he was introduced to you on the last occasion. He is a personal insolvency practitioner, well known, I think, now in the courts, and has dealt with many, many cases, a lot of them simply involving the restructure of arrears, others involving full arrangements regarding every aspect of matters to do with insolvency. He has a master's in business administration and is a financial advisor among all of his other qualifications. So I'll hand him over to you, and he will now speak to you about where we are now in terms of personal insolvency arrangements and what can be done.
Many thanks, Judge.
Thank you.
Yeah, thank you. Just check to see, can everyone see the screen there, if that's okay?
I can certainly see it.
Great, okay, brilliant. So look, I have chatted, this is the second outing in the personal insolvency CPD event. So I suppose to leave off just from the last day, you know, we're all aware of we discussed this, that there is, you know, there's definitely a stigma attached to personal insolvency. It's probably one of the negative things that when a client comes into you guys, that, you know, and if you mention the word insolvency, immediately they go, whoa, you know, I'm not insolvent, I don't need to go down this route. You know, despite the stress and everything else, I think probably in a lot of cases when I'm trying to discuss this with people, I would say, look, what we're going to do is look at a formal structure through the insolvency process. So really what we're trying to do is get a formal position, i.e. a court-approved position in relation to your mathematical situation. And I think that's really the key thing. I think Graham touched on it earlier on. This is about maths. This is nothing else other than maths. And it's about dividing up the joint income into an amicable solution that both parties can work with in relation to either keeping a family home or towards paying for the cost of kids, etc., etc. So what I did today again was, I think after talking to Nuala and after the last event, I think the case studies and the real life case studies were probably the way forward. So I have a couple of case studies that, you know, there's no doubt in my mind, you know, these people have come into your offices at some point in the past, and, you know, you're trying to look at a solution for them. Okay. So the first thing that I'm just, you know, going to focus on is that, and I'm going to just remind you again of that, in a scenario where there's a separation, it's likely that they will become cash flow insolvent. Unless they're, you know, they're very strong earners, it's highly likely that they will become cash flow insolvent. And what I mean by that is that the monthly outgoings all of a sudden are higher than the monthly income. And that may be as a result of one of them has to get an apartment, or, you know, somebody moves out, or whatever the case may be. But all of a sudden you've got a family home mortgage in a lot of cases, and then you have a separate set of costs that just all of a sudden appear because of a separation. I'm finding, and I think Graham alludes to this again as well, what I'm finding, and certainly from a lot of the referrals, a huge percentage of the arrears cases that are coming down the tracks are as a result of separation. And even when I go through the case study, it's a recent separation, this case in particular. I'm not going to bore you in relation to the stats. Morgan has already gone through the stats in relation to the number of cases in arrears in Ireland. It's about 1 in every 13 homes in the country as we speak for private homes. But the one thing that stands out for me the most is that more and more and more I'm now dealing with non-bank entities. And what I mean by that is I'm dealing with the starts, the promontorias, the everydays, the half bells, i.e. the vulture funds. Some of them are excellent and they'll work with you, and some of them can be extremely difficult, and you know, they just put the gloves up from the very, very start. So in relation to the client journey, I think it's important that you realize the length of time in relation to getting an insolvency case approved. So typically you're looking at anything between 7 to 9 months from start to finish. The key thing for the personal insolvency practitioner, in my opinion, from the start, is when you meet the client, or when we meet the client, is always to have one eye on the journey. And I'm not just talking about the journey to get the case approved. I'm talking about the journey right through to the duration of the PIA while it's in place, and equally after or post the PIA. So what happens? What's going to happen with the restructured mortgage? You know, in 20 years' time or 25 years' time, will they still be able to afford it at that point in time? So the job of a good experienced PIP isn't just to get them the deal, it's to get them through the 4 or 5 or 6 years while they're in the insolvency process, which can be extremely difficult because circumstances can change. And then post the personal insolvency arrangement, what happens? How is the debt going to be treated? Will it get them to retirement? Are they going to have to pay it past retirement? And can we prove that in court to Judge O'Malley, Costler, or whoever, that we can stand over the arrangement post-retirement, that there's enough funds available for this man or woman to be able to complete the arrangement right through that process? And that's a very, very important point, because we don't know what's going to happen in the future. What the insolvency process does, or what the PIA does, is it actually gives a fair bit of flexibility during the period of the PIA to be able to restructure, or what I would do a variation on the arrangement. And that has been called out certainly in the last year with COVID, because in COVID we were able to apply payment breaks, we were able to do variations in circumstances where people get into more difficulty as a result of having maybe no job or whatever. So there is a fair bit of flexibility in the process. So it's important that during the PIA case, there is court protection during that period for the debtors. So typically, you know, we're looking at probably 2 consultations. Then we would apply for the protective certificate. That gives us 70 days. During that period, you know, there's a hive of activity during that period. So we're looking for proof of debt. The PIPs would generally have the power of the official assignee in bankruptcy and proving debt. So, you know, that's crucial in relation to making sure that the debt owed is justified and is proven by the debtor. We'll also look for what's called a 105 valuation, and that's again critical to the proposal. The 105 valuation is the current valuation on the house. So if a creditor is owed 500 grand and the debt is 300 grand, you know, we're going to be challenging them potentially in relation to writing the debt down to the value of the house, if applicable, which again, you know, may take a bit of pressure off the debtor because all of a sudden they owe less money or potentially less money. And I'll show that in the examples as we go along. Then we call a creditors meeting, and the creditors will vote generally by proxy. I think, you know, in all the creditors meetings I've had, I think I've probably had 10 visits to the office in relation to creditors meeting. And it'll be voted for or against, depending on the creditor and the number of creditors. If it's a single creditor case, they don't even vote. We just need an email to say that they're not going for it, and immediately then we're appealing it into the courts as long as it hits the 115A criteria. If it's multiple creditors, there are what I'd call gateway clauses to get it into the 115A process. At the moment, you must have what's called a relevant debt, which is a debt on a family home. We must have a class of creditor that has voted for the arrangement. So it's similar in style to the corporate insolvency law in relation to criteria. Once we get in the case where the vote is agreed and it's voted for, well, then we'll upload those documents into the courts, get our court date, and then we hopefully get court approval. Typical time, as I said, from start to finish is typically 7 to 9 months. Okay, the costs and the fees for the debtor typically come from the Awalia scheme and from the legal aid in relation to the 115 arrangement, and generally then fees for administering it are taken and built into the arrangement. Okay, so some of the unavoidable issues that you will come across in relation to trying to get a deal in a separation case is that, well, we know mortgages have joint and several liability. That's a huge problem in relation to severing those liabilities in a informal arrangement. Well, that can be done in a PIA. Separation agreements, as you know, don't bind banks, whereas PIAs do. So again, that can be used in relation to the court process or in family law proceedings. Banks will rarely release a spouse from the liability. Again, a PIA can potentially deal with that. And some of the banks now are coming back to us with actual clauses in relation to do that, legal clauses that we can put into the PIA, and I'll show you that in a minute. And overall, what banks want when they're trying to do a deal for somebody in a separation situation is they want to see the maths. They want to see that the maths stack up, and they want to see that there is legal certainty in relation to the asset, and ultimately that they're going to get their money back. So this case, it's quite a simple case. It's a Dublin couple. They came to me fairly recently, quite amicably actually. I suppose initially they were, they had come to me initially probably about 12 months ago in relation to doing a PIA, and what I'd call an interlocking PIA, which is a PIA for both parties together. They had a family home and they had one rental investment property. About 6 months later, maybe slightly more, they came to me and said, no, we're separating, and the husband was moving into the rental investment property. So a classic situation that you guys will see all day, every day. So, you know, they came to me initially in relation to dealing with the debt, but now they're separating. So they're going to need legal advice in relation to their separation and getting that rubber stamped in the future. My role in this scenario was ultimately to try and keep them both with a family home, the wife staying in the family home and the husband moving into his effectively new family home, and getting a deal done on both. So the two salaries coming in, they were both civil servants. They had kids aged 11, 10 and 7. Just important for you to see that the reasonable living expenses I've listed there for a primary school child is 197.12 and a secondary school child is 409.91. Now, I'm not sure are any of you aware, but I mean that figure there is very, very important potentially for you guys if you're actually looking for maintenance payments, because we can easily build those figures into a maintenance program going forward for the spouse in relation to what she would potentially need to go and pay for schooling or education or whatever. And all of those figures are set out in the Insolvency Service of Ireland documents. Okay, so what I set out to do and what they asked me to do was, could I calculate a solution for both parties that they could both stay in the family homes, and also deal with potential maintenance payments in the future, i.e. what she would need going forward to be able to pay the mortgage if it was restructured, and ultimately put the kids through primary, secondary and possibly third level education. Okay, so you probably can't see that. That's quite difficult. I'm going to send on these slides, so it doesn't matter. The key things that you need to see is that in order for the maths to work, I needed to extend the term on her mortgage out by 306 months. And I fixed the payment during a 5-year term PIA at £1,000 a month. And on successful completion of the PIA, she would be paying £1,200 a month. Okay, the total debt on the for both properties was 650 grand. But as you can see, the valuation on Delhurst Court was 195. That's the husband's property, and the PPR, which is where she was staying, is 315 grand. So there was a residual debt that I needed to deal with of 140 grand on both properties by writing the loans down to the market value of the properties. Okay. If we take her maths, okay, and again, I'll send this on, but the key thing that you need to be looking at here is that I was trying to calculate out, or we did calculate out, her total income and what she would need. And you can see the gradual increase over the 5-year term, what she would need in maintenance payments to make sure she would meet her set costs, which is the cost in relation to what she needs for herself and the 3 kids, and equally the €1,000 a month that she would be able to pay the mortgage. So you can see it's quite mathematical. It sets out exactly what is required in a scenario. Now, if I can hand, or if they can hand that to their solicitor in relation to the family law proceedings, I mean, it's literally a situation whereby the separation agreement or divorce agreement just effectively needs to be rubber stamped if we get the case approved in the courts. In relation to the husband, then, what I was looking at doing there was, again, his property was worth 195 grand, and then I was able to restructure his mortgage to 250 months. It was at a 0.95% interest rate, and the payment during that term was 853 to the mortgage. And if you can see the maths on his, you can see that he will be paying, or sorry, we were looking at the payments of maintenance increasing as the kids got older. Now, I don't know, does that happen actually, and something I need to maybe run by you guys, but I don't know, does that actually happen in reality? Do solicitors look at an increase in maintenance payments in order, as the kids get older, i.e. go from primary to secondary, maybe possibly into 3rd level, or is it just a fixed amount that's agreed at the start, but maybe something that may be looked at in the future by you guys? There is an amount you can see here that would go towards the residual. So therefore, in my view, we're not prejudicing the creditor. We're bringing all the means of the debtors to the party in relation to dealing with the debt, despite the fact they're only going to get about a 4% dividend on the unsecured debt. So what I'm trying to do is at year 6, in this scenario, the clients will be out of insolvency, and they will be well able to afford their mortgage payments and able to afford them going forward. And it's also getting them through their separation or the problems with the separation. Okay, so that's a real life case. The only issue I would say I have with this case is that, and I think this will be an issue in relation to dealing with the debt, is that the creditor is promontory Scariff, who are absolutely a nightmare to deal with in relation to engagement. So, you know, it's likely at the outset when I'm looking at that, I can say, well, I'm probably potentially going to get a no vote from promontory, because ultimately some of the vulture funds don't engage and they just want to get their money back ultimately. So it's likely that case will go into appeal. It's likely that case will end up on Mr. Farry's desk, and it's likely that case may end up in circuit court in the future. But in my book, job done. We can do no more. All we can do is propose it to the creditor. It's up to them to vote and decide whether they will go for it. If I was replacing that creditor with Start, I can tell you now that I'd have the case approved all day, every day, and everyone would move on and we get on with the case. The second case is a case where, and again, you would probably come across these cases quite a lot. There's a complete stalemate in relation to the separation proceedings, and the stalemate is the lady wants to stay in the house. She is working and has a good job and feels she can pay the mortgage. The ex-husband has left and just wants to get off the debt, walk away, and he wants the property sold. Okay, and I'm sure most of you come across those cases every day. So he's moved on, wants to move on completely, and she wants to stay in the property. And ultimately, she's asked me to calculate out, or they've asked me, should I say, to calculate out what she would need to pay and what she can afford going forward. Okay, so quick scenario. The assets that they have is the family home, and the debt is 396,000, and it was a split mortgage. When they got into difficulty initially, when they separated initially, was until 2014, and they went for a split mortgage. They also have a Spanish property that's unencumbered, and that will form part of the deal. It's worth about 80,000. So, you know, straight away, I'm viewing that as that asset can be sold, and that asset can come in as part of the arrangement in relation to dealing with potentially with debt. So in the maths is quite simple. Sorry, I'll just move on to the arrangement first. What I've calculated is out that if we extend the term out on her mortgage to 288 months, and also reduce the loan down to the market value of the property, which is 295. And if we sell the Spanish property and use the funds from the Spanish property to go against the mortgage, it means it's sustainable for her. Okay, so that means that in effect, I'm writing the loan down, not just to 295, but we're actually reducing the loan to approximately 228,000. The husband has agreed that he would contribute his share of his equity on the Spanish property, okay, if the bank would agree to take him off the loan, and if they would agree to transfer the equity from Mr. X to Mrs. X, okay? So I think this was actually one of the questions that was sent in relation to dealing with, you know, title and getting someone off a mortgage. In this scenario, all the bank have asked me to do was put in effectively 0.8 into the proposal, which is in consideration of 50% coming from Mr. X. That is agreed that Mr. X will be removed from the mortgage debt, and there will be a transfer of equity from Mr. to Mrs. And that's the only line the bank have asked me to include in the proposal. And they have agreed, and this case has been approved, and they've agreed to deal with the transfer over. He's happy. He doesn't have to do a PIA. He didn't need to do a PIA because there was no need, because I was able to deal with that clause in his proposal and that. So you can see there, rather than being a 5-year arrangement or 6-year arrangement in the case of generally in a PIA, I was able to do this in 1 year. So, you know, we're able to shrink down the time of the arrangement right down to 1 year or even 6 months, and deal with, there's a small bit of residual debt. The bank are happy enough that they would write the loan right down to the market value of the property, and away we go, and the deal is done. Okay, so they're the two key cases that I've probably you would see quite regularly coming into the office in relation to the complications and why you can use those in. In one case, there's a stalemate. You know, solicitors have been over and back, barristers over and back, and they're getting nowhere. And just a simple PIA has been able to resolve that solution. You know, so that potentially will be produced in the family law court, and both parties will agree to it, and away we go, and everyone's happy and everyone gets paid. In the other case, it's the start of a separation, and you know what I've said to those individuals is actually you now need to go and get legal advice in relation to your separation separately. So off you go to your solicitors, your family solicitor, whoever the solicitor you're working with, and go on now and tell them what you're doing, tell them what the calculations are, tell them what you need to get in arrangement. And luckily it's amicable enough, but it means that they can both have their own family home. We will look for debts, or sorry, in the arrangement, we will look for him to be taken off her debt and her to be taken off his debt. And certainly you'd also be looking for transfer of equity in the separation agreement. Well, I'd be recommending that they would look for transfer of equity in separation agreement going forward, but that's a legal matter. So common resolution, I think there's no doubt in my mind, you know, I'm 5 years at this game, you know, probably since the start, there's absolutely no doubt in my mind that it's crucial that solicitors and PIPs work together in relation to family law cases. There's no doubt that if somebody is in an insolvent position due to cash flow, they need to work on it and need to work on and get it early. We all have a common goal, and the common goal is, you know, typically look after and have a duty of care for the debtors or our clients, and look at what the best outcome is for the children potentially. There's limited creditor input. The creditors don't really get to have a say in the structure of the arrangement, other than, you know, maybe at some point during the PC process what they would recommend. But you know, by and large, there's a relatively limited creditor input. You're eliminating arrears, and you're dealing with all the other debts. So in the cases I gave you there, you know, they're fairly straightforward cases, but there may be other debts that need to be dealt with. There may be a revenue debt, there may be credit union debt, there may be credit card debt, there may be trade creditor debt. So all those debts need to be dealt with. There may be other assets that need to be dealt with, pensions, pension adjustment orders, or other investments that need to be added in. Or there may be a business that needs to be split and dealt with as part of the overall. So, you know, the best legal advice and the best mathematical or dare I say, insolvency advice works together. Some of the negatives that I would have in relation to, you know, and this, you should say this to debtors, because they will ask for the negatives as well as the positives. But one of the key negatives is it's actually quite a strict regime, in that, you know, there are fixed and set amounts of money that are quite strict during that period. It is flexible in the sense that we can adjust those through a variation or potentially a payment break if something does happen, but it's quite a strict regime, and people don't like that. You know, certainly if I go to the sole traders of this world, they don't work that way. They tend to work, you know, they might have a good month, 1 month, might be a carpenter, he does well 1 month or 2 months or 3 months, and then has a bad month. They don't tend to like that strict regime of you need to pay now, you need to pay on time, and that would be probably a criticism of the overall legislation, albeit that's difficult to sort out in any scenario. The other thing is probably on the court review process, and the only, you know, I think it's a brilliant process and it does protect the debtor, but it's got quite legalistic in a sense that the original proposal generally isn't what is looked at in the court review. I think the legislators were looking at this as a simple court review, i.e. you would go back into the judge and the judge would decide on the merits of the case, etc., etc. But I think in a lot of cases, and I've seen this over the years, they actually have got quite legalistic, and generally the fight in court is normally a legal argument as opposed to the actual proposal itself. I think what's helped there is the high court cases that have come in over the last probably, you know, 2, 3, 4 years. We probably now have a book of 15 to 20 high court cases that are now dealing with those issues. So overall, I think it's a really good system. We need to work together, and I'd like to thank Judge O'Malley Costello and Nuala for inviting me to talk today. Thank you.
All right, thank you. Thank you, Eugene. I don't know whether parties can come back to me or whether you can see me now, can you?
I can see you, yeah.
Yeah, all right. My screen has still got your slides up.
Yes, we can see you.
Great. All right. Well, thank you very much, Eugene. That was certainly a very instructive tour, if you like, of what possibilities exist in terms of solutions that can be offered to clients. And that's what struck me, that basically what you're able to offer in terms of these personal insolvency arrangements is a process of engagement. And sometimes with the best will in the world, I think family law practitioners find themselves unable to acquire for their clients that process of engagement with the financial institution to whom money is owed. And it can help to close the circle, if you like, and make a solution possible. I think that's certainly the advantage of the regime. Certain things such as coming up with a valuation, a Section 105 valuation of the property. Sometimes you're one day into a family law case before you come to that. And even the reasonable living expenses as a guideline to what maintenance might be required and how you might work out a solution, that's certainly very, very helpful. In terms of the bank reviews, I'm not going to comment on the parties who might appear, the willingness of one bank or another to engage. That's, I think, depends from case to case. And again, in the Section 115A review, you're talking about proposing a solution, and you're talking about bringing that to the bank or to the financial institution, but with the advantage of the possibility of a court looking at that and deciding, look, this is fair. These people have put their best foot forward. They deserve and they have achieved a debt write-off. They've earned it, as Mr. Farry will no doubt say, and they're entitled to it. And in order to leave them in their principal private residence, the court can impose that, if you like, solution on the bank. And in the end, I would say, Mr. McDarby, it is really about the arrangement, but certainly helpful that in the last few years, the court has clarified what is, for example, a principal private residence, what is a relevant debt. All of these legal issues, as you say, have been clarified. So now matters can move that bit more quickly and hopefully will move more quickly through the process. In that regard, I think that brings us to our next speaker, who really needs no introduction. He's been mentioned a few times by everybody here. Keith Farry, a barrister who specialises in the whole area of insolvency law and bankruptcy. And I understand is at the present moment even reading for a PhD in insolvency law in Trinity, so that he'll have that to add to all of his other qualifications and accolades. So I'll hand over to you, Keith, now to bring us through the update in relation to insolvency law, as I suppose you're going to follow on from the previous lecture which you gave. Thank you.
Thank you, Judge. Hopefully everyone can see that.
Certainly, I can see it. Yeah.
Brilliant. So just in terms of starting from fresh somewhat, but then looking at personal insolvency and the updates from the last occasion, for most people, the question first and foremost is, what is personal insolvency and who's eligible? And I think between all of the speakers this evening, from Morgan through Graham and Eugene, it is an eligibility test that's first and foremost regarded in terms of cash flow insolvency. So it's a month-by-month basis. Can you meet your debts as and when they fall due? And does that mean it works for a single borrower? It does. For separated or separating borrowers, it does. Or for a fully divorced couple. And Morgan pointed out, I think in his remarks earlier, that certain circumstances do arise where one party has become estranged. One may have decided to go bankrupt, be it in this jurisdiction or in the UK, which was previously popular. And personal insolvency, based on the case law to date, has catered for and expressly provides for all of those scenarios. And the two cases that always come up in the context of a family law insolvency CPD event are a decision from Miss Justice Baker called Re JD, which broke ground in terms of the court in a 115A application being in a position to force a PIA on a bank where one borrower out of the two that were still liable for the debt had engaged. So it was a practical scenario, and I'll come to it in due course, that Mrs. JD had approached a PIP, say Eugene, for example. There was no contact from the other partner, and the bank, in that case EBS, opposed the case the whole way to the High Court on the basis that a single borrower couldn't restructure a joint and several liability. That was refused as an argument by the High Court, and the High Court confirms now that one party who wishes to stay in the house, stay in the family home, can propose an arrangement and can successfully complete an arrangement in that regard. The second, just to tie into Morgan's point from earlier, is a decision called Re Ford Egan, and that was a case where the one of the couple had went bankrupt, and the court again approved the 115A, approved the PIA application, where one of the parties had availed of the bankruptcy regime, had entirely wiped out their liability for the debt. But as Morgan points out, the security remained in place. The bank was able to rely on their security, and the High Court still found that the PIA was a better solution. It kept the family in the family home, and it wasn't unfair to the creditor to restructure with one, even though the other had gone bankrupt. So in terms of your own practice as a family law practitioner, who's eligible? Pretty much everybody. It'd be a very unique set of circumstances that would mean a debtor isn't eligible, and it absolutely works in terms of wherever you are in the process, starting the separation, starting the family law proceedings, or right at the end. All of that can be built into an arrangement by a practitioner like Eugene. That brings us then to a practical question. Well, what kind of arrangement do you need or do you want? And there's three for the most part. It's a personal insolvency arrangement if it's to deal with secured debt. So if there's a family home involved. If your client is the one who has left the family home and just wants to deal with some unsecured debts, so credit cards, credit union loans, maybe a residual debt from a buy-to-let property that was taken by a receiver and sold, there's an option of a debt settlement arrangement. And then number three is obviously the nuclear option, bankruptcy. If it's the case, and if the practitioner advises that, well, the appropriate solution is bankruptcy because you don't have the means to sustain a personal insolvency arrangement or a debt settlement arrangement, or it'll just simply be a quicker and better solution for you, then bankruptcy might be the route that you're advised to take in any given scenario. And to quote from Judge Baker in the context of personal insolvency, the Personal Insolvency Act is a considered and nuanced approach to the financial crisis and reflects a legislative choice to offer a less blunt and more flexible approach to the resolution of personal debt than was available heretofore in bankruptcy. For the most part, a personal insolvency arrangement is formulated to retain the principal private residence, and it normally gives new terms and conditions to the loan. Under, not that it's of particular relevance, but under Section 102, the practitioner is given the power to reduce the mortgage balance. The practitioner is given the power to reduce the interest rate, to increase the interest rate if he had to or she had to fix the interest rate, to give the borrower a tracker rate or a variable rate, or to specify for a period of time that the debtor needed certainty, so a 3-year fixed rate, then changing to a variable rate. And the practitioner is given the power to change the term of the mortgage. So it might well be the case that the original borrowing back in 2006 or 7, both parties had strong incomes. They hoped to pay off the mortgage by 60, and that was the expected end to the mortgage. A PIP can extend that term out to maybe retirement at 66 or 68 or 70, as the case may be, or beyond the age of 70, if the income could sustain a mortgage payment beyond that. So in terms of looking at a client that comes into your office, the PIP has the tools to look at what might be a blunt problem, arrears of 50 or 100,000, and completely erase those, completely restructure or reimagine the terms and conditions that apply a new balance, a new interest rate, and a new term. And in effect, coupled with a family law type approach, give a borrower a complete new, fresh start. Eugene has touched on it through his presentation. For the most part, the PIA operates based on the Insolvency Service of Ireland reasonable living expenses. The practitioner is the governing authority on the PIA, supervises it, makes sure that the debtor is making payments, but also feels the defence from a debtor's point of view. The PIP is the point of contact. The creditors no longer contact your client. The credit union who might have rang once a week, the creditor, the bank or the investment fund that may have sent a letter once a month, that will all be stopped. That will all go via the personal insolvency practitioner. And Eugene, as set out there, that there might be some negatives to it. Some people ask, well, is this going to be public? It is. There is a register, but unless you searched for my name on the register, you can't just simply Google it and find whether somebody has been in a, or is in a PIA or has a protective certificate. The exceptions to the rule are obviously the publicly well-known people that end up in the papers, but for the ordinary client, it's pretty much private. The terms and conditions of a personal insolvency arrangement, and Judge O'Malley Costello pointed to something that I regularly say, is that they're called an earned debt discharge. So in bankruptcy, the day you go into bankruptcy, your debt is written off. In a PIA or a DSA, the day you come out of the PIA, your debt is written off. So you might spend a month, a year, or a 6-year personal insolvency arrangement, and you pay your dividends. You are supervised by the PIP for the period of the PIA. And when you come out, having earned your debt discharge, having lived on reasonable living expenses, having paid all you can to your creditors, you're then discharged from the PIA. And the idea is that with the supervision of the PIP, if your income goes up, that's taken for the most part for the benefit of your creditors. Any inheritance, if you win the lotto or have a little windfall, that's taken for the benefit of your creditors. And it operates that, well, by the end of it, you've earned, be it some or all of the negative equity being written off, you've earned the credit union loan, the credit card debt, the other debts that were hanging out of you are written off, but you get to keep your principal private residence. Whereas in bankruptcy, especially now as we move into the new era of it not being your traditional lenders, your AIB, Bank of Ireland, Permanent TSB, the creditors who will rely on their security in bankruptcy and take back the principal private residence will probably increase in the next year or two. So that's the trade-off. Bankruptcy, immediate discharge, but pretty much no certainty in relation to keeping your family home. A PIA, a little bit more expensive, a little longer, but the certainty and guarantee in most cases of keeping your principal private residence. A number of things that I touch on and that people ask from a family law point of view, the difference and distinction between the family home and the principal private residence. Under the Personal Insolvency Act, there is a definition given as to the principal private residence, and it's where one ordinarily resides. So from a family law context, it might well be correct that if it's a single dwelling that both parties own in the state, it would fall under a Code of Conduct on Mortgage Arrears definition of primary residence for both of those people under CCMA and dealing with their mortgage arrears. But for personal insolvency, it's only the person who ordinarily resides in the property that can call that their principal private residence. That might not seem hugely relevant at the start of a process, but currently as the law stands, in order to engage the court jurisdiction to ask the court to review a refused arrangement, one has to have a relevant debt, and a relevant debt requires that you ordinarily reside in your principal private residence, that the PIA is designed to keep your home. So I appreciate the slides are going to be circulated. I won't spend too long going through the definitions, but that's set out in Section 2 of the Act. And the difference then is obviously the primary residence under the Code of Conduct on Mortgage Arrears. The eligibility that I set out in terms of the overview is that the debtor's insolvent. There's a case called Re Newsome from the High Court that deals with the definition of insolvency, and Mr. Justice MacDonald, sitting as the High Court judge at the time, dealt with that in terms of the ordinary query that some people might have. I've positive equity in my property. My house is worth 300,000. The loan is 200,000. Therefore, I'm not insolvent. Therefore, I can't go and meet a PIP. That's wrong. It's a cash flow test to ascertain whether the debtor is eligible to get court protection. The most fundamental part of the court protection process is the first step that Judge O'Malley Costello or any of the circuit court judges dealing with protective certificate applications deal with, is the issuance of the protective certificate. That is the start of the clock ticking in terms of bringing a resolution to a client. And Section 96 is the safety net under the personal insolvency regime. So be it the scenario that Morgan points to, a creditor brings a bankruptcy petition, a protective certificate stops that. If a creditor is looking to appoint a receiver, a protective certificate stops that. If there's repossession proceedings in the circuit or the High Court and the debtor gets a protective certificate, the protective certificate stops that. So again, I say that in the context of clients who have been at loggerheads separating, but ultimately both of them want to work together to save the family home, be it for the children or for the reality of the settlement of the family law proceedings. The timing and the benefit of getting to a personal insolvency practitioner has to be seen in light of the protection that the protective certificate can bring, and the breathing space, to borrow the kind of examinership context, the breathing space it gives to Eugene then to bring heads together, to figure out what the income is, to figure out what mortgage might be able to be paid, or what kind of maintenance might be needed to sustain something going forward. A couple of the effects, obviously Section 96 sets out regular debt proceedings, Section 96(2), that no bankruptcy petition can be brought. Judge O'Malley Costello pointed to the benefit of the Section 105 valuation. Again, there's an inbuilt statutory process where the creditor, the practitioner, and the borrower effectively have to get to an agreed valuation. The first port of call is the borrower tells Eugene, I think my house is worth 100,000. The bank then contact Eugene and say, well, I think it's worth 150,000. And Eugene's then in the middle, and he can agree with the consent of the borrower and the bank that, okay, we'll settle on 125,000. If it's the case that that can't be agreed, the parties can appoint an independent valuer. And if the parties can't even agree on the name of the valuer, then the Insolvency Service of Ireland can appoint a valuer who presents a valuation that's fully binding on everybody. So again, think of that in the context of settling a family law case where you might both have valuations, the clients can't agree it. Well, the PIA process can bring that to a head. So from my point of view, and I appreciate that Eugene touched on this at the start, I think Graham did as well, the process works that the protective certificate is issued by the court. All of the creditors engage with the PIP. They submit a proof of debt, effectively telling Eugene that they're owed a certain sum of money. They then engage with the PIP a little bit further, and they say, I think an example there was made by Eugene to Start Mortgages. A regular submission by Start to a personal insolvency practitioner would be, we will support an arrangement that reduces the debt to the value of the property, so long as you pay us an interest rate of 3%. And there's a process under the Act that enables the creditors to give suggestions or submissions to the practitioner as to how to treat the debt. Once the practitioner has it drafted, the practitioner agrees it with your client, the debtor, and for the most part, nothing leaves the PIP's office without, if it's a family law tripartite type solution, without the debtor being fully satisfied with it and if signing off on the PIA. The PIA is then sent to the creditors. The creditors get to vote on the proposal, and then it's either accepted or rejected. And to accept a proposal, you need 65% of the overall number of creditors to vote in favor of it. You need over 50% of the secured creditors, and you need over 50% of the unsecured creditors. Most normal Irish households end up with one dominant debt, which is the family home mortgage, and then a few little debts that are normally accumulated over the years. The process developed that if the family home creditor voted no, they'd control, for the most part, at least 65% of the overall debt. They usually controlled the full 100% of the secured debt, and then some part of the unsecured debt. That was leading to a process that all the proposals made by PIPs were getting rejected, and that was the end of the road. That changed in 2015. Section 115A was introduced into the legislation. And again, to borrow from Judge Baker, who broke most of the early ground in personal insolvency space, she said that Section 115A gives the court a far-reaching power to overrule the result of a vote at a creditors' meeting if the court is satisfied that a debtor may, as a result of the proposals contained in the PIA, continue to reside in or not be required to dispose of an interest in his or her principal private residence. The court must be satisfied before engaging its jurisdiction that the proposal is not unfairly prejudicial to the relevant creditor. That was the introduction of a process that ultimately now has developed a body of a case law that I think Mr. Fagan is going to touch on after my presentation. So Section 115A means that the practitioner can bring an application before any of the circuit courts or the High Court, depending on the debt. And if the court is satisfied that the gateway provisions, the entry requirements as they currently stand are met, can proceed to then consider the proposal that has been calculated by the practitioner. The gateway provisions for a review are that the debtor must reside in the principal private residence, and that the principal private residence mortgage debt, to simplify it slightly, was in arrears on or before the 1st of January 2015. From experience, most of those cases pointed to in the statistics have been in arrears. I know the figure is longer than 2 years. Most of those started off in arrears in 2011, 2012. And yes, they're in arrears for more than 2 years, but they've actually been in arrears at this stage for 8 to 10 years. So the entry requirements, in arrears, and you reside in the principal private residence. And depending on the type of case, you either have one creditor who votes no, and therefore you're enabled to bring an application before the court, or you have a class of creditor who supported your arrangement. By way of brief example, if your family home creditor voted no, but your unsecured creditors voted yes, so your credit union and credit card voted yes, you would have a class of creditor which enables or brings about the jurisdiction for the practitioner to put an application before the circuit court. The process was slow initially, certainly beginning to speed up. It certainly has sped up a lot since virtual hearings have taken over, but precision is key. Eugene's right that for the most part, applications now turn into fully fought technical legal objections, but that's the nature of the beast, that a creditor is instructing a solicitor and counsel to find anything that could possibly be wrong with the personal insolvency arrangement in order to ultimately succeed with the objection, because they don't like the proposal, they don't like the write-down. It doesn't matter what ground that a creditor might succeed in their objection on. The objective is just to succeed, simple as that. I suppose there might be a slight disappointment as I get to the end of the slides that there isn't much new case law, but that for the most part is actually an endorsement of the system. Most of the big issues have actually been trashed out. There are a number of decisions currently awaited from Mr. Justice Sanfi, but as I'll touch on in terms of family law, certainly all of the principled type points have been decided by the High Court at this point. Couple of scenarios, I won't dwell on these in circumstances where I see the time, and B, I think Eugene's examples are as relevant as any. Couple of examples back in the day, to start mortgages, mortgage balance 237,000, house worth 115,000. The debtor presented to the PIP with an interest rate of 2.25 and an obligation to pay a monthly mortgage of €1,377 per month. They couldn't afford that. They instructed their personal insolvency practitioner to draft a PIA to reduce the debt, reduce the interest rate. And way back then, Start Mortgages voted no against it. The question is, well, what did the practitioner draft? The practitioner extended the term of the mortgage to age 70, which is fairly uncontroversial in personal insolvency space. The write-down of the mortgage was from the 237,000 that it started out at down to the value of the property, which was 115,000. The debtors only had to pay interest-only payments of €47 per month. for the first 12 months at an interest rate of 0.5%. And then after the PIA, the mortgage bounced back up to a 3.5% fixed rate with capital and interest payments of €645 per month. The Circuit Court approved that, and ultimately all of these cases turn on what's considered the comparison with bankruptcy, or to go back to the test articulated by Judge Baker, unfair prejudice. So how or why did the court determine that a reduction of the debt to 115,000, a fixing of the interest rate at 0.5% for 12 months and then 3.5% for the remaining term of the mortgage? How did the court determine that as fair? Well, it was in the context of what would the creditor achieve were it not for the PIA? If the creditor repossessed the property, if the debtors went bankrupt, what would the creditor get? And the maths and the figures set out that in a bankruptcy scenario, the creditor would get 41% of their money back. They'd get 41 cents in the euro, whereas under the PIA, they were being offered, even though they didn't like it, they were being offered 69 cents in the euro. So the court could, on a financial and mathematical basis, find that this was not unfairly prejudicial. The same then for unsecured creditors. If you can see at the bottom of the slide, unsecured creditors would have got no return, a nil dividend in bankruptcy. Under the PIA, they were being offered 2 cents in the euro. And again, the court could find that this wasn't unfairly prejudicial. The main case that dealt with a huge host of issues, started in Trim and finished in the High Court, was the case of Re Callahan, which dealt with warehousing, which many of you will have seen and heard of in terms of a solution offered by banks. This was a case, property in significant negative equity, balance on the mortgage of 285,000. The value of the house was 105,000. Again, the practitioner wrote down the mortgage, not the whole way to the value of the property, but wrote it down to 120,000. And in shorthand, KBC voted against the arrangement. They suggested that the PIP should have two parts to the mortgage, one being the active portion, so to take, for example, the 120,000, but rather than writing off the 165,000, that should be parked, that should be warehoused until the debtors came to the end of the term of the mortgage, when they would have been reaching the age of 70. The creditor argued that there will be an ability for the debtors to sell the house when they get to age 70, clear the warehouse debt, and figure things out at that point. The Circuit Court and the learned Circuit Court judge refused that argument from KBC and called it kicking the can down the road. And the High Court and Judge Baker at the time agreed with that and said, and again looked at the figures and said, no, the write down was fair. The debtors were earning their debt discharge. They were in a PIA for 6 years, for 72 months. They were going to have to live on reasonable living expenses. And then when the court crunched the numbers, it again looked at the financial outcome and said, well, in a bankruptcy scenario, the creditor would get 32 cents in the euro, so the 16 plus 16 versus the 42 being offered under the PIA. And for unsecured creditors, they were getting 2 cents in the euro in the PIA versus nil in bankruptcy. Those are relevant in terms of what credit clients might expect to achieve, but in applying a family law dynamic to my slides, and noting that I'm coming to the end of my presentation, the Re-JD decision is ultimately the Bible in terms of family law jurisprudence. That, I won't take you through the numbers, write down, restructure, but the facts are of relevance to your practice. There was a separation in 2012. The loan went into arrears in 2013. There was unsecured debts that both parties had taken out with a view to assisting the co-borrower with his business. The Mr. refused to make any payments. Maintenance orders were obtained in 2014. They were paid and not paid from time to time. And then the borrower had went and got an attachment of earnings order at €120 per week. But there was no consent from the co-borrower to the PIA. And there was no evidence before the court, I guess, that he was going to continue to pay maintenance because he just simply wouldn't engage in the process. So to take, if it was Graham, for example, the court requires, and it does in most of the insolvency courts, that the co-borrower will be put on notice of the PIA. doesn't have to engage, but should be notified. And the High Court found, in light of the arguments made by EBS at the time, EBS argued that it was unfairly prejudicial, and that there was insufficient grounds and no evidence as to the income of the co-borrower to satisfy the court that the arrangement could be approved. And in effect, the creditor also argued that it was unfair to write down one co-borrower's debt and leave the other one outside of the arrangement. And to quote from Judge Baker, just paragraph 39 very quickly, it's clear that the acts do not mandate that joint debtors would make a proposal for an interlocking PIA, and indeed it envisages circumstances where a debtor who has joint debts may make a proposal for a PIA without the cooperation of or any form of involvement with the co-debtor. And I think Nuala is still probably online. There was another iteration of that case due to be heard on Monday in the High Court that I think is going to settle, but may end up in a High Court written judgment in due course. Just to finish up, two final cases. Payment history is something that always comes up. The High Court has authority and jurisdiction to look at the conduct of debtors coming into a PIA. It's always advisable that debtors will be paying whatever they can afford to pay towards the mortgage. But if they haven't been paying, that doesn't put them outside of the personal insolvency process. But as Eugene will tell them as soon as they get into his office, as soon as they start the PIP process at the very latest, they need to start making payments. A couple of other things: that a PIA is possible even if the debtors don't have enough income to meet the reasonable living expenses. The court will look at it in the context of, well, what would rent cost in the area? What would social housing cost? And look at the payment in the context of the alternatives. Long-term extensions are possible. The High Court decision called Reed-Dowling, where the High Court approved a term extension to age 83. I think, in fact, Eugene had a case approved on Monday where in the High Court by Judge Sanfey, where the term extension was into the debtor's 90s. So depending on the income, depending on the position in terms of pension income or assistance from family members, creative solutions are certainly available. The final point was the Ford Egan decision. I think I've given you reference to that. Certainly, it was a separated parties where the husband had gone bankrupt in the UK and had all of his debt written off. So that High Court decision in Reed JD has been re-emphasised by Mr. Justice MacDonald, and again approved a single debtor being able to propose an arrangement. So in conclusion, personal insolvency does work for most people. Living in the principal private residence is crucial, and it's currently living in the principal private residence. That's the crucial consideration. It's never too late to go to a personal insolvency practitioner. The well-reported decision in Re Ronan Ryan was after a repossession order had been granted. Personal insolvency is onerous. It does take all of your income for a period of time, but once you earn the discharge, you're entitled to return to a normal semblance of living post the PIA. And in a family law context, it absolutely works. It normally puts the co-borrower on notice, but if you approach a good PIP, get good advice, a personal insolvency arrangement can be built into a family law settlement. So I'll hand back to the judge.
All right, I'm just conscious that we could probably take another hour, Keith, I think, to listen to all of the points that you wish to make. And certainly what we can see from all of this is that the insolvency process provides a myriad of solutions, if you like, which are not available outside of that process. And that all of the work that's been done over the last few years has had to clarify what is available and indeed make it easier for debtors to avail of that, as a result of all of the cases that have been heard and all of the cases that you and others have been involved in. I'm conscious that we're almost out of time, but during the course of the lockdown at the beginning, we were forced and indeed delighted, I suppose, in insolvency matters to go online and to be able to deal with a lot of these cases remotely because they're on affidavit. And in that regard, I asked my judicial assistant then to put together a booklet of the authorities, which he kindly did, and we're going to make it available to yourselves so that you'll have an opportunity to read it. So I don't know, Mr. Fagan is my judicial assistant. He's a degree in law and he's studying for the bar at present for King's Inns. And I don't know if in a couple of minutes you can introduce the company at large to the booklet that you put together, please. Thank you.
No problem, Judge. I'll pull it up now. So this is a booklet of cases that myself and Judge O'Malley Costello have put together. I think in the area of personal insolvency, there's been over 40 cases which are contained in this booklet, which have dealt with seminal issues. It's somewhat slowed down recently in terms of how many issues are being brought to the High Court. So if I demonstrate with this case, Mr. Farry brought up the issue with relevant debt and the principal private residence. So if you were to look at that, you could come to this booklet and look down under issues under this section 115. So we have cases such as Callahan, which Mr. Farry spoke about earlier. And if you look at perhaps the recent case of Ree Murphy, in that case, you can click on that and it'll link you to this short explanation or summary of the case. And having gained some understanding of the case in that, you can click once again on the title of the case and it'll bring you down to the full judgment. So hopefully, if you'd like to do any further reading in the area, this booklet will be of assistance to you. It contains, by and large, most of the seminal judgments in this area and might prove to be useful going forward.
All right, thank you very much. It certainly was a help to me and I hope it'll be a help to some of you in just easily accessing the cases, which are of course also available on the court's website. So Lindsay, I know we're at a point where we're almost finished the seminar and we have so many questions. So I don't know whether we can continue. Will we continue for another 5 minutes?
Yes, Judge, I was going to suggest, I think maybe about 5 or 10 minutes and we'll see how we go. Perhaps if the speakers would just put on their videos and unmute themselves so they can answer the questions, that would be great. I think, Judge, you have some of the questions that were sent in advance. Maybe we go through those first and then if anything hasn't been addressed, there's a couple of extra questions here. If we have time, we'll go through those.
All right. Well, I just picked out one question for Mr. Shelley. Maybe if we could go to you first. One of the questions is, and I'm just amending it a little bit, is who should go first, insolvency application or family law proceedings? But the question also arises, who should go first, bankruptcy or family law proceedings? Because I know that that's arisen as well in some of the questions. So what would you say to that?
Well, if you're going down the personal insolvency route, it seems to be that the best way to do it is if you can get everyone to agree, it's better to resolve your differences in terms of third-party creditors together. So I think even if there are differences about other things, going to a PIP together and packaging everything together with family law proceedings seems to be the best way. If things are contentious and one of the parties is refusing to participate, it makes it, obviously this is very case dependent and each case will turn its facts. From my point of view, I think there'd be a lot to be said for going down the route of securing the assets from the non-participating spouse. If there's one of the spouses that's being very objectionable and difficult to deal with and very unreasonable, it makes sense to either through the Family Law Protection Act or through family law proceedings to protect the assets from that person, and then if necessary, go through a personal insolvency. I think one of the questions that we were asked involved a situation where the bank is on side with one of the spouses and the other one totally disengages. You don't need to go through a personal insolvency arrangement if you have the bank on side, if you can get the court to sign off any judicial separation or a divorce or under the Family Law Protection Act and the bank are on side. So I suppose the answer is it depends. Certainly, bankruptcy is not to be, I think, gone through lightly, and certainly I wouldn't want to commingle that with family law proceedings.
All right. The reason that I picked that out is that very often it comes, when I'm dealing with matters, people would come into court and say, would you please adjourn? There's a bankruptcy petition listed, or would you please adjourn? We're dealing with insolvency. So I think sometimes family law practitioners, the questions here that they're trying to understand is, should they be, adjourning their family law proceedings, if you like, to deal with other applications to a court. And it seems to me that for insolvency, certainly I think you'd probably agree, Mr. Farry, would you, that if you need a protective certificate, you need it now rather than later?
Usually, yeah, unfortunately.
All right.
I think my view, Judge, would be that I would be dealing with the insolvency position first. I think that can be a more creative way to resolve issues around securing accommodation for dependent children and the family home and so forth. But also too, how is a family law court judge to determine proper provision if the actual financial circumstances of the parties are still up in the air, so to speak, if one of the parties is seeking an insolvency arrangement? So I would be of the view that if you can get a couple into a personal insolvency practitioner who can show that there is another way, perhaps through the mire of debt and the agony of a breakdown, which doesn't necessarily resolve in everything being sold, then that is the most sensible thing to do first. And as Eugene has outlined, the timeline in an insolvency application can very often be half what it is in family law proceedings. So it is actually quite possible to get through the insolvency courts before even indeed your family law court hearing would be coming up. So I really think creatively it offers us as practitioners another something in our arsenal that actually helps us outline to a court what may well be proper provision for the parties going forward.
So I think really that all of the other questions that were in the questions posed, if you like, to us before the seminar have been dealt with by the practitioners in their answers. But maybe you have some more questions, Lindsay, do you, that you think might?
Yeah, there's just one or two. I won't go through all of them, but one of the questions that came in, and maybe this is for Eugene, maybe, is that the question was, is it where there's a personal insolvency arrangement, is it unrealistic for older clients, people in their late 40s or into their 50s, to go down that route in circumstances where, in I think one of your examples, there'd be an extra 24 years on the mortgage? But I think Keith maybe referenced that in some instances you go to 80 into your 80s and there's an arrangement.
Yeah, I think it's about the financial position of the individual. So, you know, certainly where there's pension, post-retirement, etc., there's absolutely no reason why they can't extend the mortgage past retirement age, and that's happening more and more and more, where elderly couples are coming, and not necessarily in separation cases, but elderly couples are coming saying, look, I still owe 100 grand on my house and it's worth 400. You know, I live in Raheny or I live in Blanchardstown or whatever. What'll I do? I'm due to retire. And they get the letter from the bank to say, you know, we want all our money back because your term is up. I think insolvency is absolutely positioned for those people.
Sure. And then maybe just one other question, which was that, what is the likelihood of a party who enters a personal insolvency arrangement being able to access credit in the future, as in, are PIAs notified to the credit bureau?
As at the moment, I know there's discussions between the central bank, who control the credit bureau, and the ISI. I think that will happen. I don't think it happens at the moment, albeit that a personal insolvency arrangement, as soon as it finishes, 3 months post the completion, it comes off all registers. So if a bank or a credit union do a credit check, there's no history of it. So the essence of insolvency is to make somebody solvent again, so their credit history is repaired effectively. Because remember, right during the personal insolvency or the debt settlement arrangement term, they're not in arrears anymore, so there's no reporting of that debt. So therefore, during the arrangement, their credit is repairing anyway, and then post the arrangement, it should be repaired.
Okay. There's one other question here, Lindsay, that perhaps it's a bit complicated, but I don't know whether anybody would like to answer it. If a PIA is accepted and it goes ahead and concludes, so we're into 6 years later or 12 months later, whatever, what options has the party who took the PIA or who entered into the PIA, I suppose, got regarding resolving the legal ownership of the property? So I suppose where the other hasn't got the PIA. And how can they get the other party off the title deeds? So that's a bit of a thorny one, isn't it?
Be no mechanism under the Personal Insolvency Act to do that. There's in fact a decision that says you can't do that, the Matthews decision. So the PIA can only affect your rights and interests. It can't take someone off in that context. I suppose that would go back to a Graham Hanlon question, that's where the family law comes in. That's where you might get the order in the family law courts. So the PIA will sort out your debt, leaving you in a position to pay the debt, and then let the family law court clarify the ownership and transfer the equity in the property. Is I suppose where it goes.
Yeah, I think that's it in a nutshell. I see, Mr. Hanlon, that you're agreeing. All right. Yeah, so are there any other questions then?
I think we leave it there, Judge, given the time. I think it's
yes.
we're running about 5 minutes or so over. I'm conscious that it's
all right
in the evening and we've been on for over two hours at this stage.
Okay.
But I think if anyone has any specific questions, if they want to email them to me, and I'll get them to any of the speakers, and I think any of the speakers will be very happy to with any questions if there's anything specifically that must be addressed by anybody. So I suppose it falls to me to thank you, Judge, for kindly chairing the conference this afternoon, the seminar, should I say, this afternoon, and also to our speakers. We're absolutely delighted that everyone so graciously gives their time, and I know time is precious. So if on behalf of the Executive Committee, if I could thank each and every one of you for kindly giving your time this evening, it's really greatly appreciated. And I can tell you that at the height of it, we had over 170 people tuned in to listen, which is just phenomenal, even in terms of our recent attendances. So we'll leave it there, guys. Just to remind our viewers who are tuned in that the next seminar will be an afternoon seminar again, and that will be on the 18th of February at 4:30, and we'll be dealing with evidence and family law. And we have some top-notch speakers. We have Inga Clissman, Senior Counsel, who will be dealing with financial evidence. We have Mark Tottenham, BL, who's going to be dealing with expert evidence, and we have James Daly, BL, who's going to be dealing with affidavits and paper evidence. And indeed, that seminar will be chaired by Circuit Court Judge Sinead Ní Thualachain, who's kindly agreed to give up her time for that. So without further ado, I think we'll sign it off, and good evening.
Thank you, and thanks to the Family Lawyers Association for the invaluable service that you provide. Thank you.
Thank you.
Thank you.